All right, good morning, everyone. Thank you so much for joining us. My name is Kat. I work with Avenidas. I will be your moderator today. I wanted to let you know that we are recording this session and it will be available on our website afterward. This morning, I have the absolute pleasure of introducing our presenter, Deborah Kramer Radin. Deborah G. Kramer Radin is managing partner at Kramer Radin LLP in downtown Los Altos and is a past board member of Avenidas. Her practice concentrates on estate planning, trusts, wills, post-mortem trust administration, probate, estate dispute resolution, charitable giving, tax planning, elder abuse, and end-of-life planning. Deborah is certified as an estate planning, probate, and trust law specialist by the State Bar of California Board of Legal Specialization and was named a Northern California super lawyer in 2019. Today, we also have Paula Wolfson with us. Paula Wolfson is the manager of the Avenidas Care Partners program, which provides multiple counseling and supportive services to our local community and to long-distance relatives. Paula is facilitating multiple support groups by Zoom and managing a crisis intervention and consult line during this pandemic. You can contact her directly at 650-289-5438 or email her at pwolfson@avenidas.org. And I will be putting both of those details in the chat box for everyone. Both Deborah and Paula will be around to answer any questions that you have, so feel free to leave them in the chat box while the presentation is ongoing, or hold on until they open the floor for questions after the presentation. You are all currently muted, but we will allow you to unmute once the presentation is over, and you can freely ask any questions that you have. Without further delay, I will hand things over to Deborah so she can get her presentation underway. Thank you so much, Deborah.
Okay. Let me just get my screen shared. And can everybody see my, can everybody see my screen?
We can see you currently.
Yes, we can see you.
Just me. Okay, so I apologize. Let me just, I just need to share my screen. There we go. Okay. There
we go.
Good?
That's better.
Yes.
Wonderful, everybody. Okay. Thank you all for your patience with me today. I just want to prep my power has been out since Saturday, and I've had cold showers basically since Saturday, so I'm a little more discombobulated than I would like to be, but I think we'll have a smooth presentation going forward. And thank you, Kat, for the introduction. I just want to let you know, yes, there'll be plenty of time for questions at the end or in the chat box. I'm not going to be monitoring the chat box, but I know questions will be coming, and I think Kat will be reading them to us afterwards, or I'll go back while Paula's talking. We'll make sure everybody's questions are answered.
I can help with the chat room too.
Thanks, Paula. Okay.
Thank you, Paula.
Okay. So the goal today is to give everybody in the room, hopefully, a bit or as much as possible of what you're looking for. I think everybody in the room is coming at this from different angles. So there may be people who have estate plans already, time to start reviewing them. They've been thinking about this, or things that you know aren't really working. So some of this is for you. Others are thinking, wow, this is a really good time to start planning or get my plan in order that I've been meaning to do. My daughter's been nagging me about this for ages. It's time. So that might be you today. Maybe you have some free time this morning and that might be you as well. And this might be your plan, or you might be assisting somebody else with a plan. So you're coming at it from the caregiver or the agent or trustee perspective. So all of that I will try and cover. It's going to be high level, but then we'll go deeper with any questions you have. So most people's objectives with estate planning is a few things, but it really comes down to control. what do I have today? What am I making decisions for about myself or about others today? And I would like to keep doing that in the future as long as possible. If I cannot, who would I trust to step in my shoes, speak for me, act for me, be on the phone on my behalf? That's part of it, the control piece. And where would everything go if I'm gone? Who might be next in line, and how do I make those transitions happen smoothly? Also avoiding the court. There are very few people I know, at least in my world, who would enjoy or think it's a good idea to be involved in the probate court at any point in our lives or post-death. I'm also talking about the things that are different. This program 6 months ago, some of it's the same and some of it looks quite different in the last 6 months or the last 4 months. The court process is as bad as it was 6 months ago or a year ago, is really, really difficult right now. Our court just last week announced they are cutting, our local court, 50 staff members permanently. So what was slow before is that much slower today. And tax reduction. Lots of ways to do that. Most people would say if they had 3 buckets and they had a choice of which buckets to provide for, family and loved ones might be one, their nonprofits, their community might be another, IRS is third. For most people, the IRS is not the bucket that they choose. So we're looking at the other 2 when possible. This next slide, I included it because this is really not such a legal answer, a legal slide, but I found over the last few months that as good and thorough as our estate planning documents may be, if the people that you have entrusted with potential care don't know that they're supposed to do something, they don't know each other, or you don't have some of these important team members, things can fall apart and things can be extra stressful. Clients who are at, in nursing homes or assisted living or at home, they can't get to the services that they need. The services that need to come to them aren't allowed to. Family can't visit. All of that you've all been experiencing or hearing about is really, really true. So if there is an attorney or medical team or a neighbor who, or Paula, Avenidas, these people who are important should at least know about each other. It doesn't have to be complicated, but it's really, really important. So I add that in as you're going through this, the program today. I think I skipped ahead by mistake. Okay, and then basic estate planning. There have, I think the chat before I got on, there have been changes, not necessarily in trusts over the last few years, but in how we may want to draft trusts, what our trusts will say or what our estate plan says. So I'll talk a little bit about that. These are basic documents that we're going to be talking about today. So I'm going to skip this slide. And there are lots of ways to transfer what we own. So if we're talking about the piece where I mentioned earlier that one of our important goals is how do we transfer what we own, what belongs to us, to whomever else we choose in the future. There are lots of ways to do it. Again, sometimes an attorney needs to be involved, or it could be you have an IRA and you're naming a beneficiary for that IRA. So again, sounds simple and kind of common sense, but make sure if you have those types of assets that you actually have named a beneficiary and that beneficiary is who you want it to be. It's not somebody who's not there or doesn't need the money anymore or whatever it might be. So now is a good time while you're thinking about this to double check those kinds of assets. All right, so for good estate planning, some people say, all I need is a will. Very simple, and that might be true. And it may not, but so if it is true, the benefit of a will is that it is very, very easy to put together. It gives us direction. So if you've done nothing else at this point with planning, it's important to give us some direction. So a will is like a letter to the probate judge. It says, "Dear Judge, I'm gone. Here's where everything I own is ending up, where I want it to go. And here's my executor. Here's the person who's going to carry out my wishes on my behalf. Valid wills I've seen could just be on a yellow notepad. I've seen them on, quite honestly, on the back of a cocktail napkin. It could be valid. It could also be problematic. The problem potentially, especially in California, with a will alone and no other estate plan, really are twofold. One is that the will only is useful at our death. When we're gone, a will has some power. Until then, it doesn't do anything. It also doesn't do any good until it goes through the probate court process. And as I said, and I say it because it's true, because we live through this now, if we try and go to a probate petition, we try and file a petition today, it's about 4 to 6 months before we can actually start the process. I have 3 probate matters right now going on. All in these 3 cases, they all have real estate in Palo Alto or Mountain View, and they all 3 in these cases have reverse mortgages on the homes. We cannot get to the reverse mortgage. We can't deal with the how to pay off that reverse mortgage. The reverse mortgage company in 2 cases has said, we don't care how slow your court is, we want to be paid, and they're threatening foreclosure. So a will alone, depending on what you own, is very stressful, and it's unnecessarily stressful and slow. So not usually my advice. As I mentioned, the probate process is slow. It is very expensive. All of the fees in probate are based on the assets that we are carrying through this probate process. So I don't want to talk too much more about that. I can talk more if you have follow-up questions. So most people in California, if you own, here's the number, if you own more than $166,000 and change, it's $166,250, I think, right around there. That has changed in the last couple years. That's the threshold for whether or not we need a probate proceeding at our death. So 166 or so. So if we own real estate, we own more than that, then that's when a trust becomes really useful and worth considering. This is the piece that I want you all, if you have your trust already drafted, or you are asked, you are a future trustee, a successor trustee, it's really important to know, first of all, the different parties in the trust and what this trust says. What are those instructions? So in simplest form, a trust is a very long set of instructions. By the time I'm done with it, it's about 35 to 40 pages, but it really is just a set of instructions. Those instructions are triggered by different events over the chronology of our lives. So the day we sign our trust, and if you're a married couple, it's typically the 2 of you, the spouses are the settlers of the trust, a single person. So let's say it's me, if I'm a single person, I'm the only settlor. That will always be me. So the day that I sign my trust, I am all 3 parties. I wear all 3 of these hats, and I'm giving myself instructions. My trust jumps forward. It will say, if I, settlor, am incapacitated, I'm now moving my hat to another trustee, and I'm asking that future trustee to follow my instructions. I am still the beneficiary. That's still my hat. And I'm asking the trustee to take care of me, whatever I need. Review that, again, if it's your trust or if you're a successor trustee for somebody else. Are there other beneficiaries? Might this be a blended family and the beneficiary could be another spouse, or it could be a child with some extra needs, and that child needs to be cared for? Or if let's say it's me and I have that child who needs extra care, have I properly provided for him as a beneficiary if I'm incapacitated? This has also in the last few months become more and more important to plan for. So that was one triggering event. Next triggering event in a trust is a death. married couple, it's the first death. What does the trust tell us to do? And I'm going to talk about that in the next couple slides. And then the trust, of course, jumps forward again. Now we're all gone. I'm gone as the settlor. There's definitely another trustee, and there are future beneficiaries. Are those beneficiaries who you want them to be? Is it still, does the document still say what you want it to say? Let's see. Okay, I think I just talked about that, so I'll skip that slide. A revocable trust for any of us, I just described it as a set of instructions. Another visual that I use all the time because it's simplistic, but it's accurate. A trust is also like a teacup, and it holds what we want in that teacup. And the way it holds those items, like our house or a brokerage account or a savings account, is how we title that asset. So if my home is titled Deborah Radin, comma, trustee of the Radin Family Trust, my house is in that teacup. Some things don't end up in the teacup, and that's okay. We'll talk about that in a bit. You can see that little saucer underneath the teacup. I'll talk about that later. That's your pour over will. It's the saucer that collects anything that might have spilled out of the teacup, but they work together. So the trust, we want things titled in the trust properly. Now also is a good time to double check. Have I taken my house out of trust because I refinanced? Have I opened up a new brokerage account? I forgot to tell my broker who's on my team that I have a trust. Make sure those connections are completed. All right, so this is the part. Let me see if I can do this on Zoom. Not always the easiest for me. Easier with a notepad with you around my kitchen table or around a conference table. This is a really important slide for married couples. If you are not married, but your trust was created when you were, this might be important as well. For those single people, if you want to go get a tea and come back in a minute, that's fine as well. But the trust, that triggering event I mentioned at the first death, will tell the surviving spouse something. It will either say very, very simply, everything that is mine is now yours, or it could be the opposite. It could be quite stringent and demanding and say, my half of our estate is for you to use, but it will never be yours, actually. Or there's a middle ground, there's a hybrid called a disclaimer trust, important to understand. So, easy example, let's say my husband and I have an estate of, we're fortunate, we have a $6 million estate total. And unfortunately, he had passed yesterday. I can pick on my husband because he's not here. I'm alone at the office right now. So he passed yesterday. I'm the surviving spouse. We have a total estate of $6 million. With a simple trust, I call it a sweetheart trust. My husband tells me, Deborah, my $3 million is now yours. I then move forward with a $6 million total estate. Very simple. Or he could have said, with an A-B trust, my $3 million is available for you. However, and I'm going to go back and forth between these slides, there is a brick wall between my $3 million and my husband's $3 million. And forever forward, I, as the surviving spouse, will manage two separate trusts, one on my side of the brick wall and one on my husband's side. His side, with an A-B trust, is irrevocable, meaning that I can use his $3 million. I can live in the house. I can do whatever I need to do for myself, but I cannot change his words. They're locked. My half is available, and I can do whatever I want. The hybrid of those two trusts I just described is called a disclaimer trust. What that means is this. If we have that same $6 million estate, I have a choice. I can keep those two buckets separate, one side and the other side of that brick wall, or I can say, if I can do this, oh, I don't know if it's going to disappear. Well, that's okay. All right. When I practiced this yesterday, that brick wall crumbled down and it disappeared. So anyway, imagine that I have a choice. My husband's telling me, Deborah, if you don't need this brick wall, get rid of it, do away with it, and it will crumble in the real world, not on the slide today. And that means that I can decide, do I want my husband's entire 3 million, meaning that I have 6 million in my control? Or perhaps I want to set some of his 3 million aside. So I decide how much is on his side of the brick wall. Could be 3 million, it could be $1 million, it could be nothing. I get to base my decision on the estate tax laws that are going on in the year he passes away. This is a big change over the last few years. So under our current estate tax rules, and this is for singles, married couples, everybody, we each have a very, very high exemption, the amount we can pass along tax-free at our death. So under current tax law, that exemption is about $11.5 million. So if we were so fortunate, we had $11.5 million to pass along to our loved ones, whoever we choose, there is no estate tax due. That number is supposed to drop. This is the uncertainty, part of the uncertainty in our laws these days. This is a big one in my world. That exemption of $11.5 million in 2025 drops to $5.5 million. And it might change. It depends who's governing us, what the IRS has to say, what's going on in our world. So I prefer, if you are comfortable with it, that you have the choice of deciding, do I want to keep everything? Do I want to split? That's a tax planning tool and benefit that we have if our estate plan has some flexibility. So all of that said, once you've got that trust and it says what you want over those triggering events, you might have left something out of the trust. It might be inadvertent or it might be intentional, and we can deal with all of that with good planning. So the pour over will, as I mentioned, it's the saucer underneath the teacup. It collects anything that spills out, and your will should be saying, if you have a trust, the will says anything left in my saucer is poured back into my trust. So what's left in that saucer these days, again, should be under $166,000. Small checking accounts, your cars, personal items, whatever you might not want to put in that trust. So also I have found I've said this before COVID, but now even more important, a financial power of attorney and understanding it has become even more important. Again, whether it's yours or whether you are acting for somebody else, a financial power of attorney can be very short, very simple, and that may be sufficient, or there may be things that we really want to add into a power of attorney. For example, if somebody has CalSTRS or PERS or a specific account, sometimes a basic financial power of attorney won't cover needing to make decisions or permission to make decisions for those types of accounts. So make sure that your power of attorney actually is going to do what it needs to do at that point in the future. Or again, if you're an agent, if you're acting under a power of attorney, does the document that you have give you enough authority and power to do what you need to do? So I often tell my clients, or I always tell my clients, I think that the power of attorney that I've created for you is the best legal document ever, or I wouldn't give it to you. But I also want you to go to wherever it is, Schwab or Vanguard or Bank of America, and ask them, do they have a specific power of attorney for their accounts? And that should augment, they should work together with the legal document and the specific power of attorney for that bank or that financial institution. It could make everybody's lives that much easier in the future. And again, if we can't get to Bank of America these days, this is my document and I've named my son as my agent, I want to make sure he can walk into Bank of America for me. I don't need to make a trip. I don't need to leave my home if it's not safe to do so. Together with the financial power of attorney, your advanced healthcare directives, equally important. Different, it's not financial. This is very personal. And Paula will, I'm sure, we all talk about healthcare directives. There are many, many variations to an advanced healthcare directive. Most important, whether you've got the one that your doctor gives you when you go in for a checkup, whether it's one that Avenidas has given you, whether it's one that an attorney has drawn up, or you find it online, or whatever however you're getting that advance directive, make sure that it says what you want it to say, that it reflects your wishes, not somebody else's, not the attorney, not your doctor, not California, that it really is reflective of you. We do our best to provide those instructions and have your healthcare directive reflect your wishes. I do find also, though, if you're comfortable having these conversations, that your directive, that the directions you're giving are even more specific beyond what a healthcare directive perhaps can reflect. So I do advise my clients, as uncomfortable as it is, try and have conversations with those you've appointed. Again, whether it's a sister or your children or your neighbor, whoever it is you're appointing to step in your shoes, to speak for you, to act on your behalf. Does the healthcare directive talk about end-of-life wishes in different scenarios? And as we've seen the last few months, our or maybe not seen, but you've read, you've observed other people, our wishes may change, and make sure that your healthcare directive currently reflects what's going on in your life today. I know some people ask, because it's a fairly recent law, about the assisted suicide laws that we have in California. It's not called that, but I want to say that is not something that can be reflected in an advanced healthcare directive. So if that's something that you're thinking about and you say, oh, I need to update my directive to reflect my desires if I'm at end of life, that law requires that if this is mine, I need to be the one asking for those instructions at end of life. I can't give that power or can't put that wish onto somebody else. It has to be me. But the directive, whether, again, it's a basic directive that you get from your doctor, it might say exactly what you want, but make sure in that case that another document or another way of expressing your wishes you've provided for funeral, cremation, whatever else that you might want or you don't want. Make it clear. Together with an advanced healthcare directive, the post form has become more and more useful and potentially really, really important as part of estate planning. So the post form, I know my background is blue, but I always call the post form the bright pink form. It's kind of a magenta pink. It's a document that, probably many of you in this room know about it, but it's a document that only you and your doctor or your medical team, your doctor's assistant, signs off on this form. It's not something your attorney can sign off together with you or you alone. It has force when you and your doctor have reviewed it together and signed off. I look at the post form as if you have one, and the ambulance is called to your home at 2 a.m., it's as if your doctor is standing in your living room with you at 2 a.m. giving everybody directions. So potentially very useful. If you know what you want, it's important. If instead you say, look, I want my son to be called and I want him to make these decisions for me, make sure your post doesn't say something that might be different than what your son might say. So again, keep that communication going. Make sure your team knows what's going on. I add this slide in because this number has changed a little bit over the last few years. So I talked about the estate tax exemption, the amount we can pass along over our lifetime of about $11.5 million. The $15,000 is an annual gift exclusion, meaning that every year, if you were so fortunate and generous to do so, you could give everybody you wished or you wanted to share with $15,000. It's under the IRS radar. You don't have to report this. And if it's $15,000, that doesn't accumulate over your lifetime. There are lots of ways to do this. And if it's useful, and potentially it is, or it's just something you want to do, it's worth thinking about. All right, so the other piece to this, again, not quite so legal, but kind of a funny picture, but the small property gifts can be really, really important. So I go back to how important communication is. Many people say, oh, my kids, nobody in the family wants the china, nobody wants that silver, they don't want to, they're not bothered, they're mobile these days, they don't want the pictures on the wall, so I don't care, I'm going to just let them all deal with it. Or nobody would ever fight over these things, they're not worth anything. The small, relatively, the personal property items in my world become so, so important. So I can't express enough how important, if you've got people that you do want to provide for, they're items that have sentimental value, please make sure that your executor, your successor trustee, your family, whoever it is, knows what you want. It's heartbreaking for me to see children fighting over the one ring, or the rocking chair. Everybody sat in that rocking chair with grandma as she read them nursery rhymes. Everybody wants that rocking chair, even though nobody can really sit in it anymore. So make sure you've expressed your wishes. People don't have to take those items if they don't want, but not only does it clarify things in the future, it really does, people are very touched when they know that they've been provided for specifically. So it could be rings, it could be tools, it could be the bikes in the garage, whatever might have sentimental value to your family or your loved ones. Okay, I think, oh, that's if you're if you're sleeping well. I breezed through the very high level estate planning documents, things that I've seen come up the last few months especially. I do have slides following for Avenidas, and I'm wondering, is anybody, Paul or somebody else, able to just say a few words about what Avenidas can provide in this picture?
Yeah, if you want to advance the slides, I'll talk. I actually didn't know. So I want to do this very quickly because you've gotten a lot of really great questions. I've already looked at a lot of the questions. So Avenidas has closed the building, but we're continuing to function as best we can through Zoom, phone calls, emails. We have so many different programs going on. I'm really proud of what we're doing. So we are continuing to do delivery services, friendly chats. You can call the door-to-door program. I really suggest you look at the Avenidas website, the www.avenidas.org, and then you can see everything we are doing. We're calling it Avenidas Without Walls. And so Rose Kleiner is closed, but they're still serving clients in many ways. We have different phone lines to call in, our information and assistance line, case management. That's all under Avenidas Care Partners. And we're going to be doing more town halls in the fall on all these related topics. So my phone line is a crisis intervention line, and I am actively running caregiver support groups. So contact me if you want to be in a group if you're a caregiver. And so Deborah, I have many of my caregivers on the Zoom call with you today. And I think, let's just start. I have one question that covers what I think a lot of people are asking on that chat line, is the fact that if you've got two spouses, one is newly diagnosed cognitive decline or is very disabled, cannot function, that spouse is the total caregiver, is in charge of everything. The able spouse is fearful now, of course, of getting COVID or being diagnosed with dementia. There's no family, no friends. They have nobody to set up, and any of these documents has the person to take over. What professional person or who would then be somebody they could rely on if the able spouse dies first? That is a question coming up in all my caregiver groups.
Okay, so first of all, if the documents, the estate plan that I just described is already in place, go back and look at those documents and see what do the documents say will happen next. So you start there, and then you figure out what documents, which of the documents can be changed, if they can be changed, and then you look at what are the other options. So I explore this with clients. It could be you know, as I say, it could be a trusted neighbor. It could be a friend. If there are people in your life that just are not the right fit for different reasons, there certainly are a variety of professional trustees that are out there in our community. As with every professional, I know, you know, we're used to the newspaper articles with the inflammatory and sometimes justifiably concern about everybody, but you've got to do your due diligence. And there are wonderful private professional fiduciaries in our community that serve in all different roles. There are also different, there are different groups that serve in different roles. But let's say I'm talking about a private professional fiduciary. Some of them will assist while you're alive as well. So if they're, for example, they're named as a successor trustee, they may, if this is what you want, have a continuous care contract so that they might be able to assist with getting a bookkeeper, getting a little bit of help for you if you need it, making sure your groceries are purchased, whatever you might need. So it's worth exploring.
So fiduciaries, what are the names of the other kinds of professionals or groups?
So beyond the private professional fiduciary, so a good website if you want to understand that concept is PFAC, Professional Fiduciary Association of California.
Okay.
There are other groups, you know, and the cost is all different and what you might need is different. You know, just as another example, not a competitor, but Jewish Family Children's Services in San Francisco. They have continuous care as well. Might not be the right fit for people down here, but does that answer the question?
Yeah, that will help. Okay, so are you looking at so there are a lot of different questions that have come on.
I think I'm going to stop sharing my screen and then I can see the chat.
Okay.
Okay, sorry. No, I'm not. I'm there.
Okay.
All right, everybody. So should I go back up? I should go to the beginning.
So there was the first one about any changes in living wills and trusts, and I think you addressed that already.
David, I think I addressed that for you. If not, we can follow up. The AB trust you want to change. Oh, sorry. This is an important question from Mary Fran. If you have an AB trust and this is two spouses and you still are able to change it, it's worth considering, do you want to change it? So you're giving up the potential by getting rid of the B, the irrevocable portion. You're saying, if I pass, I trust my spouse, it's all his, he has full control. So it's worth considering, do you want to change that? If you're the surviving spouse and you have an AB trust, more and more of our clients are considering court petitions. There are other ways to eliminate that irrevocable trust if it's appropriate to do so. So it's worth considering. But I need to see the document itself. Yes. Sorry, let me go on down.
And then the next two were for me about the disabled spouse. But the question then becomes, so if somebody, married couple, the other person is diagnosed with dementia, Alzheimer's, Parkinson's, you know, my group, this comes up a lot. And I always say to the person, no matter whatever you do, the first thing you do is go consult with your elder state attorney and update all your documents.
Right.
Okay.
It's really, again, it's important that the documents are updated to current law to reflect who should be next in line. You know, I'm just lots of examples. I'm assisting 3 daughters and their mother now, and one daughter, the plan was put in place when the daughter was in a terrible, terrible marriage, and very restrictive trusts for this particular daughter. And there's a trustee, a bank who's in Ohio, doesn't exist anymore. So it's really problematic, but it's this old AB trust. So we're actually working on petitioning the court to modify these old provisions that are no good anymore. A lot less expensive and helpful to deal with it now while you can.
Right. I think the important thing for everybody to realize is you want to change things and update things while you are still competent and you have capacity, because once you lose that or that changes for you, that's when everybody in the family has to pay a lot of money and end up in court, right? to pursue other avenues to change things.
Yes, it's true. It is true. And you know your family best, or your wishes best, more than anybody else. So an estate plan is that much more powerful when these are wishes that you have expressed, not that somebody else has put on you in the future. Do it now.
All right.
So I think this question was sort of answered. Mary Fran asks, we are older parents in 60s with adult children ages 23 and 19. We currently have distributions for our daughters from age 25, 30, and 35, but are considering changing to age 30 and 35, given the size of our estate. Your thoughts, and how does it work in practice? Meaning, is it put in a trust for them, or does the survivor trust continue until liquidated? Her concern is the complexity it may add to the executors, trustees, and duration to execute.
Okay, good questions. So while you both are, the way a typical trust would be drafted, and I'd have to read your trust in particular, nothing goes to your daughters until you are both gone. So when I talked about the triggering events of a trust, those gifts to your daughters would not be triggered until the second death. So has nothing to do with what the surviving or survivor's trust says or the bypass, any of that. So this is future. Once that future happens, if you feel ages 30 and 35 are more appropriate for your daughters, then you're looking at this. So I always look at you know your daughters better than, well, certainly better than me, but probably better than your attorney does. You would know what their capabilities are. Might they be unduly influenced? Might this gift, if they did get this gift before age 30, sway their future careers in a negative way? These would be things to consider when you're picking the distribution ages. And then to the second part of your question, it's not necessarily complex, but you have to think about who would be in control. So if you've got a sister you're naming as your successor trustee, how old will your sister be when your daughter is 35? And if you say, this is still okay, my sister's in pretty good shape and she wants to do this, what's the backup plan? Could she name a successor? Is there the ability to name a professional fiduciary or somebody else in the family? So you've always got that flexibility built in if these ages seem somewhat far in the future to you. So it doesn't have to be complex. You just have to think about the reality of, okay, if this is what's going on, my daughter needs something for medical, or she needs a house, or she needs to move. Are the funds available, and is the right person put in place to manage this for her? All right. I think I answered that question.
Yes.
Okay.
A shorter question is it easier to change a will than a trust?
It depends. Well, for you, writing up a will, it's probably less expensive to change a will, most likely, but depending on your wishes, the same wishes that you put in a will that you're changing in your will might be identical to what you'd be changing in your trust. So it might be the same cost. It's the post-death that is dramatically different, really truly dramatically different cost-wise. The trust, unless there's something going on that would be unusual, a trust is a lot quicker and a lot less expensive to administer after a death than a will.
In that particular case, what if the person who has died is the abled spouse, the remaining spouse is totally disabled, incapacitated, there's a house and assets? Do they just rely on a will, or do they need to have a trust?
They would want a trust. And the trust also, I don't know if I breezed over this in the presentation, the trust not only helps that all of the post-death that I just talked about, but it is the best legal document that I think we have in California for managing that well spouse, that able spouse, if you need help during your lifetime. A power of attorney and a house are insufficient if you need something during your lifetime. A will won't help.
Okay, thanks.
Sure.
Let's see, there's another question from Arona. Can you make a $15,000 annual gift to more than one person? Is there a limit for the total amount you can gift each year?
So the limit per person is 15. You can make that gift to as many people as you want. You could write a check to everybody in this Zoom room today if you felt like it. And I don't mean to make light of it, but there's no limit to how many you can give. They just have to be separate people.
There's a question from Sue Dremen. I don't know about a durable power for an aunt, and they want to set up a will and a trust, but they want to make sure whatever they do protect her from being, I think, scammed or being financially abused by somebody. It looks like she's in a budding relationship. So Sue, I think Deborah and I would tell you that no matter how good your documents are, this might happen anyway. There are people who are going to try to finagle older adults. So Deborah, I have a response to that, but I'll throw it to you for the moment. What are your thoughts?
So starting, I would want to talk to your aunt, or somebody, an attorney should be talking to your aunt. What does she want? Because these would be her documents. And if she's able to be in control now, I'd want her to consider this. And I would ask her, would you like your niece perhaps to be a co-trustee with you, to be able to see your bank accounts and monitor? If you're writing checks every day to the same person for whatever it is, sending money off to some person in Florida, because it happens with clients that I have. Do you want somebody to be monitoring and assist you? Things can change though. She might say yes today and change her mind tomorrow. And if she's mentally competent, she may unfortunately have the right to make changes. But Paula, do you want to?
Yeah, what I've noticed, and I want to say that I've been doing this 30 years. I've been a geriatric social worker. Soon I'm going to need one, but right now I'm still okay. And what I've noticed about this particular set of dynamics is that when somebody starts being financially abused, often there is an early change in their cognitive status and abilities. So one thing it's important to do is get them in to see a doctor to be evaluated. And then there's also issues with self-esteem, depression, having relationships with people who they're codependent on, taking advantage of them. So this becomes a much bigger picture than a legal matter. Just having these documents don't always solve things. This is where you need your team of a doctor, attorney, and supportive family members.
And I want to add on to Paula what you just said. Protecting yourself. I tell clients it is so important while you're able. Have a doctor, have that threshold. This is my cognitive ability today and I'm doing well, so that as things change over the years, you've got in your records what might look different, right? Do it now, it protects you. It's not to lose control, it's to protect you. Mm-hmm. Okay, Sylvia, 2 out of 3 do not have wills. How can I get them to okay, 2 out of 3 adult children do not have wills. How can I get them to consider advanced planning? Yeah, and boy, I wish I could, this is somewhat of a mother question also, in addition to a legal question. Tell them that, there are lots of different ways. This is very, very stressful to you. As a gift to you, you want them to get their planning in order. That might be a little bit of honesty or mother guilt a little bit. I know, and I'm not advocating this, but some parents are able to pay for this. Say, look, you're going to get married. Here's, when my children, my nephews and nieces turn 18, they get a healthcare directive and a power of attorney from me. That's their 18th birthday present from me. Just reading the papers these days, the world, again, 6 months ago was uncertain, but it truly is front and center in the newspaper and on every single day. And it's true. So it doesn't have to be complicated or expensive to plan, but maybe that helps. Have them talk to your attorney. That might help. Threats sometimes help as well. I want to provide for you, but I don't want to provide for you until your estate plan is in order. So I need to see your plan because I have the right to make changes if I wish to do so. So let's get your planning in order and then I'll be comfortable providing for you in my plan. Mm-hmm. Hope that helps.
So another question we have is, again, from Arona. I understand there are changes to the tax of benefits and the required minimum distribution for the beneficiary of an IRA. What are these changes?
So if we inherit an IRA, this is not between spouses. So if I inherit my mother's IRA, it used to be old law. I could stretch out, I had to start taking distributions, but I could stretch those distributions out over my lifetime. That has been accelerated. There's some other changes, but I have to fully distribute, I think within 5 years. So an IRA, income tax wise, is not the best asset to inherit. But it's just the income tax will be accelerated. The income tax due is accelerated. If that answers that question.
That's good. There's another question here. We have 2 more questions I see. I did have another question from Mary, who is asking a follow-up to the annual gift. She was asking if for a couple it would be $30,000 for an annual gift, because they can each. Okay.
As long as it's each coming from you. So if I can't give away my husband's separate property, but if, sure, it's from each of us, correct.
The next question is, had own POA form me for my mom. I notarized but afraid to mail. Does it take away mom's power to act on her own? Also, TD Ameritrade has their form that says, ends if mom is incapacitated. It defeats the purpose of POA. The account is in her trust.
Okay, breaking that down, let's see. So valid, notarized but afraid to mail. I'm not sure what that means. If you can make a copy, if you're more comfortable with faxing, there shouldn't be social security numbers on a power of attorney. So I'd need a follow-up clarification on that. But if TD Ameritrade has its own form that they say ends upon incapacity, older powers of attorney makes no sense. They expired after a certain number of years. I would want somebody to reread the power of attorney that you're referring to and see if that really is correct, or if somebody misstated, because that kind of doesn't make sense to me. Or is there a way to update that so that it does continue for her lifetime, even upon incapacity? All right. Mara's question, sorry. And then the account is in the trust. So that would indicate if an account is in the trust, remember it's in the teacup, a financial power of attorney probably doesn't have any effect. It's very rare that a power of attorney will have effect on an account that's titled in the trust. The only way somebody most often can get control over that account, if it's in that teacup, is by coming on as a trustee. They need to wear that trustee hat. That may be the problem. Mm-hmm. So then Mara asks, can an executor of trust also be one of the beneficiaries? I want to split it up 3 ways. One would be my sister. Can she be the executor? And then what is the average price to prepare a trust? So can a beneficiary be an executor, the successor trustee? Absolutely. You just know, I always say my trustee is up here, the beneficiaries are here, and the trustee has a very high fiduciary standard to treat all of those beneficiaries at that level the same. They all have to be treated fairly. So you need to pick somebody as your executor or trustee who can do that, who's not going to be selfish, who's not going to be lording it over the other beneficiaries, who's going to do her job. And then certainly that's not unusual. The average price to prepare a trust, really, I think it varies. I can say in our firm, a complete estate plan, all the documents that I talked about, deeds, everything, on average will be $3,000 to $5,000 total. 5,000 might be way on the high side, 3,000 depends. A single person, it will be less. A married couple, it will be more. If you have more real estate, it tends to be on the higher side because we have more deeds to prepare. But others in the community may charge differently. If you have a current attorney, just because you haven't seen that attorney in a few years doesn't mean they wouldn't be ready to get a phone call from you. So revising documents that I have prepared are less expensive than starting all over again. So, all right. Oh, and then Carlette asked about where and how do you specify who gets the small property gifts? Really good question. With our estate planning, we provide a blank, or it's a form that says personal property wishes, and you can handwrite that. So California law says if the will has mentioned that I'm going to prepare a statement, this is I meaning these are my documents, a statement leaving my personal items to certain people, and I actually write that statement myself, that written statement will be incorporated into the will and the trust at my death. So it's something that you can do on your own and change over time. It would be separate from your will or your trust, or it could be in your trust if, or your will. If you know absolutely this is what I want and I want it in black and white, there could be benefits for actually putting in your trust or your will.
Okay, so there is a follow-up. I sent Valak a copy of Mom's POA. They sent their POA form, which I completed and notarized.
Okay.
Afraid to mail, fearing Mom could no longer act on her own behalf, in addition to me acting on her behalf.
So a power of attorney should not, again, I'd have to see the forms, and make sure you understand the forms thoroughly. I'd call Valak and make sure they explain these forms to you. They should not, a power of attorney should not say, Mom, in this case, is giving up any control. You're just able, if necessary, to be her hand, to be her eyes and ears, to be her feet, to act for her. But you shouldn't be acting instead of her. So make sure Valak explains that form, or that an attorney or somebody else explains the form thoroughly. All right. Did we get?
We have 2 more questions that came in.
Okay. I'm going to start. Rona, I'm going to answer yours first, because maybe I'm not being clear. The personal property statement, yes. So it is not a will. It should not in any way say, this is my last will and testament, or this is my trust. It's not for leaving a house. It's not for leaving cash. It's personal items. So yes, that can be in your own handwriting. The important part, if it's in your own handwriting, a couple things, is that you're not somehow invalidating another estate plan. You're not invalidating your trust or your will. That your wishes are actually followed, so that writing can be found. We don't want it stuck in a drawer and your executor or somebody in the family says, I don't really like that, and it disappears. So make sure that, again, your team knows about it. You can type it up too. Yes, that's fine. Just as long as it's expressing your wishes. I think that's what's most important, and that people know about it. And then I'm going back up. Mara asked a follow-up question. If the executor who's a beneficiary doesn't follow the rules, can the other beneficiaries take action? Absolutely. Again, I go back to, what do the documents allow or not allow? What direction do they give? The probate code gives very strict instructions for a trustee. A trustee has very, very high standards to uphold. And if he or she is not following those standards, what do the documents say? What does the probate code say? And there's definitely the ability to remove that trustee. It's just a matter of how we do it. Again, depending on what the instructions are. Absolutely. Unfortunately, that happens. It happens as well. So again, another reason to be aware of your plan and make sure you've picked people you trust. Okay. Can you list assets in another country? Can an asset from another country be in a trust? In my experience, at times I have said, for example, all of my interest in my cottage in Sweden goes this way. I have found it has limited use and it is not the best estate plan. I highly recommend, if you've got properties in other countries, that you make sure whatever those probate rules in those countries are, that you know what they are and that you've dealt with it there. That cottage in Sweden cannot actually be titled in your trust. Words regarding what happens to that cottage perhaps can be in your California trust, but you can't have a deed to a California trust if that property's in another country. So I've had attorneys in other countries say, Deborah, why did you do this? If you had just told them to get a will, you know, and wherever in our country, it would have been so much easier. It's in our language. Our probate process is so easy here. You've really complicated the planning in our country. So I highly recommend dealing with it there.
Like Mara has a second part of her question.
Okay.
When she passes, do all the beneficiaries see what's in the trust or only the executor? If they can't see what's in the trust, they won't know what the rules the executor has to follow.
Okay, so Mara's question goes back to communication. California law says when a trust becomes irrevocable, and again, there are different points when it would be irrevocable, everybody in that document has the right to read that document, to see it. So if a trustee is doing his or her job, once you've passed, that trust is irrevocable. That's the way it works. And everybody gets a copy of it, everybody. And then they have certain rights that are that the law provides for them. If that trustee doesn't share the document, then we've got a problem. So that's where you'd think about, and I don't always advocate this, but is it worth sharing your trust or your documents with others just in case? Do you want everybody in the family to have a copy, or is that too much? Do you want your financial advisor to have a copy, or your CPA, or your trusted eldest child, even though your sister is your trustee? So again, make sure those who need it know how to find your estate plan at the right time. And a couple more questions. IRAs are not in trust. Does that mean they are subject to probate? Oh, really important point. So the answer should be no. Sometimes it's yes. So an IRA, any assets that have direct beneficiaries, such as an IRA, 401k, a pension perhaps, life insurance, generally those assets are not in your trust. Make sure you've got a beneficiary designated. If the beneficiary is on file and that beneficiary is alive, or it's a charity and that charity is around, no probate. Don't worry about that. It's if there's no beneficiary surviving or you didn't name somebody, then we're dealing with the probate court. Is common law marriage recognized in California? So Sylvia asked if common law marriage is recognized in California. Generally, no. I'm not a family law attorney, so there are layers of how you provide for a significant other who you're not married to, but we don't have common law marriage in California. There could be contractual obligations that could occur. So I don't have a great answer without knowing the situation. And then Arona asks again, or not again, asks, since you don't think they're good tax benefits to just have a beneficiary for an IRA, do you suggest an alternative? Not necessarily. I mean, sometimes this is where a financial advisor being in the room would be helpful to answer this question. I would look at everything you have, and sometimes, again, I'm not a financial advisor, so I'm not saying this is always right, but sometimes it's worth using more of your IRA if there are other assets that you want to give to other people later. That might be an answer, or it might just be the way it is, that you're giving something, but something in your estate is going to be taxed a bit higher. Or if you are interested in charitable planning, it is always, or not always, it is generally a good idea to use the IRAs in that charitable planning, since charities still get that IRA tax-free and individuals would not. So there could be different options depending on your total estate and what's important to you.
I think
Okay.
we actually caught up at the questions.
Yeah.
I wasn't expecting that.
And the last question, oops, sorry, I don't know how to not share my emails. So the last question is how everybody's functioning these days. So everybody's different. Our office is in downtown Los Altos, as we talked about at the beginning. And we have 6 attorneys in the office. I have a staff of about 20 total. And when everything first happened, I think like the rest of us, we were completely remote. We went from being very, very in-person, sharing tea, hugging each other, just very, it was all in person, to nothing in person. And now different attorneys are doing this differently, but I have found the estate planning work that I do has become even more personal, if that's possible. I am, I think for everybody, being in a Zoom room is difficult. It's not the same when there's something stressful going on or tragic going on. I can't reach across a table, and this is the worst part for me. But I am making house calls. It's lovely for me. I'm seeing people's gardens. I'm meeting their neighbors. I'm meeting their dogs. The children they're comfortable sheltering in place with. I'm meeting them. I'm very, very, very rarely going into homes. It's usually in the front yard or the backyard. We have lots and lots of safety protocols, I think, like your dentist these days. So we are seeing clients. It's different. So we're making it work. Kind of like a dentist's office, it feels like. All right. If there are no other questions, I think, again, as Paula said, we are all here. Avenidas has been an amazing resource for me, for my clients. So that's why I'm in this room today. Last question about pricing. $3,000 to $5,000 for what? So finishing on pricing, because that should be my first front and center comment. So that would be a full estate plan. So that would be a trust, a wills, so single person, or wills for two spouses, financial powers of attorney, advanced healthcare directives, privacy waivers called HIPAA waivers, deeds to real estate, to retitle, to get them in that teacup, married couples knowing community property versus separate property, that's part of the planning, the personal property statement, being here as a resource. I get phone calls, emails, all day. And there are others in the office that assist with answering those calls and those emails, but we get questions. That's part of supporting our clients. That's basically what it covers. There's some other documents, making sure you're retitling assets appropriately, your IRAs have the beneficiaries that you want them to have, and then getting you to other resources if that's appropriate.
So Deborah, I do have one last question. I don't know if we're running out of time or if we have a bit more time, but the other thing that does come up now with COVID, cognitive changes and emergency health care crisis, when should somebody file for a temporary conservator guardianship petition, and how do you do that?
Okay, so conservatorship process is, I have time to touch on it. It is a whole other topic, of course. In my world as a planner, it is my last resort, but sometimes it is the best resort, and it's a necessary inevitability. So the conservatorship process is, we go through the probate court. It's like a guardianship for a minor, for an orphan, but it's for an adult when that adult is not safe. Going back to that aunt, if she's subject to undue influence, if her doctor feels that she's at risk, a conservatorship process may be inevitable or may be important to protect her. So Paula, you asked the timing. I think if the estate planning documents themselves are not enough to protect that person, that elder, conservatorship is an important option to think about. If that person's at risk, if, I had a client, she still had mental capacity, but she found somebody online in Florida who kept saying, if you just give me a little more money, I can afford to come out here and I'm going to marry you. I adore you. And all I need is a little bit more money. And she gave away thousands and thousands of dollars. And we could not stop her. Her doctors said, yeah, she's at risk, but not quite enough. We could not convince the court in that situation to follow through with the conservatorship. So it had to get worse before we were able to properly protect her.
Okay.
There's always a balance. A conservatorship process looks like a litigation. It looks like you are filing a lawsuit against that aunt that I just described. And it's very intrusive, potentially. It's very expensive, potentially. Lots of people know about it. The person being conserved potentially knows about it. So it's worth understanding, but not necessarily something we'd want to do right off the bat if the estate plan works.
And so to avoid all that, what's really important, I think most people sometimes ask me this question is, when do I need 2 letters from 2 different doctors to declare that my durable powers are active because my person now is lacking capacity? So do we always need those 2 letters to activate the durable power of attorneys?
Oh, that's a really good question. So durable power of attorney, again, you look at the document itself. If that triggering event, somebody stepping in, requires 2 doctors before that person steps in, then we need 2 doctors. I have found over the last 4 months or so, it's hard enough to get 1 doctor who trusts, who knows you well enough. 2 is sometimes really difficult. That would be a reason to revisit your financial power of attorney. Do you still want 2 doctors? That might be too much.
Okay.
Also the reason, going back to getting a starting point, you know, getting those regular checkups so that if there is that triggering event occurring in your life, you've already got a starting point. So you're not trying to find a new doctor today. If your doctor's retired, reach out to somebody, get on somebody's appointment list. And,
thank you.
Okay. And Marie sent me a nice note. Thank you, Marie, for that. That's always good to hear. We do our very, very best to take care of people. And I do say that with all truth. And there are so many good, I say this also with truth, there are so many good estate planners out there. If you have somebody that you work with already, reach out to them. If there's anything that piqued your interest in the last hour or so, make sure that they know you're around and ask them if it's time to update anything. They'll know their documents better than I could.
Oh, that was a lot of information today. And it looks like we're coming up on 12:15. Thank you so much, Deborah, for all of your answers, for all of the information that you've given us today. This event was really incredible. So,
my pleasure. Follow up, everybody. Do you know, you're here, and I usually start by saying we talk about such yucky, you know, kind of unpleasant topics in this last hour or so. So you've thought about it. You took the time to be on this, in this meeting, in this Zoom room. So feel comfortable and good about yourselves. You've accomplished something today, and take the next steps. Okay.
I consider that everybody's creating their family legacy, that this is a contribution to creating whatever it is you want your story to be told within your family of how you took care of each other.
Mm-hmm. Absolutely. Take care, stay safe. You know, thank you all for your great questions. It made this much more interesting, I think, for everybody. So.
Thank you. Yes, absolutely.
Thank you, Deborah.
You're welcome. All right, everybody, enjoy the afternoon. Stay warm, or stay cool.
Happy birthday.
Not too warm.
Thanks, Deborah.
Happy birthday.
And it's my birthday today. Thank you all.
Oh, happy birthday.
Happy birthday.
Thank you. Thank you, Jean.
You're welcome. Love you.
Thank you for being with us on your birthday. Yeah.
Yes, Jean is checking in from Illinois right now. That's how much she loves us.
Oh,
Yeah. Bye-bye.
Bye.
Well, thank you all so much.
Thanks, Deborah.
Okay. Bye.